Am I audible to all?
Yes.
Yes, ma'am. Good evening. You're audible.
Good evening, sir. Good evening to all. A very warm welcome to Lawvs' first National Moot Court competition. We honored to have our learned judge, Mr. Bharat Malhotra, sir. We welcome your lordship. Before starting with the argument, we would like to brief the bench about the functioning of the courtroom. I, Neha Mishra, will be serving you as court master and we will assisting you with maintaining the decorum and to assist the honorable bench. The court master will act as facilitators between the bench and the counsels. The court master will time the arguments and intimate the bench accordingly. Your Lordship is requested to please seek our assistance whenever it is required, as stated in and Rules of Lawvs First National Moot Court Competition 2025. Each team will get 30 minutes to present their case, including 5 minutes will be given for rebuttal round and sub-rebuttal. Subject to the discretion of the Honorable Judge, each team shall intimate the postmaster in regard to division of time between speakers. Only one speaker from each shall be permitted for the rebuttal and sub-rebuttal. The order of the presentation is petitioner number speaker 1, petitioner speaker 2, respondent speaker 1, respondent speaker 2. Rebuttal petitioner any one of the speakers. Sub-rebuttal is respondent any one of the two speakers, where sub-rebuttals will be permitted only at the discretion of the judges. Each speakers have 10 minutes to represent themselves. The judges may exercise discretion for extending the time for the oral rounds beyond the time specified in the rule book. The rule book provides that time extension up to 2 minutes in permissible of each round. The team code for the petitioner is 22 and the team code for the respondent is 71. If taken time for the rebuttals, mention that. The total time is 50 minutes, with the petitioner speaker 1 presenting their side for 10 minutes and speaker 2 for 10 minutes, whereas the respondent speaker 1 presenting their arguments for 10 minutes and the speaker 2 for 10 minutes, and 5 minutes will be given for the rebuttal. I now would like to seek the permission of the bench to start with the proceedings.
Please, ma'am.
Thank you, Your Lordship. I now request the petitioner to start the proceedings.
May it please His Honorable Court.
Please, ma'am.
Yes, if I may, can I refer to you as my lordship? Yes.
Please. Or
yes,
refer to me as sir. It's fine. Whatever suits you.
Yeah,
Refer to me as sir, whatever suits you.
Yes. I appear before this honorable court as lead counsel for the petitioner, Speaker 1. With me is my co-counsel, and we stand before this bench today to argue on behalf of this of citizens of Vrindavan, whose fundamental rights are gravely impaired by the arbitrary actions of the state. It is with due reverence, my lordship, that we appear before this honorable court on behalf of the petitioners. The present matter before this court is not merely just a legal dispute. It is a profound conflict between the constitutional rights of citizens and states' heavy-handed actions. This case presents a fundamental clash between the state policy and the constitutional rights of its citizens. The present matter is an appeal against the proposed plan of the state government to evict the residents of Vrindavan and restrict access to the city, which we submit is a grave infringement upon the fundamental rights guaranteed to the petitioners under the Constitution of India. With your permission, my lordship, I will be addressing the first two issues, and my co-counsel, who is speaker number 2, will be addressing the remaining of the issues. The council would like to seek the permission of your lordship to proceed with the statement of jurisdiction.
Please.
Much obliged, my lordship. So this honorable court has jurisdiction to entertain the present special leave petition under Article 136 of the Constitution of India against a judgment and order dated 28 March 2023 passed by the Honorable Court of Allahabad. This honorable court has original jurisdiction under Article 32 of the Constitution of India to entertain petitions for enforcement of fundamental rights guaranteed under Part 3 of the Constitution. The present matter involves substantial question of law as to interpretation of Article 14, Article 21, Article 25, Article 26, and Article 300A of the Constitution of India, which are of general public importance and require authoritative pronouncement by this honorable court. It is also argued that there is an inconsistency with the following statutory provisions, that is, Environment Protection Act of 1986, Water Prevention and Pollution Act of 1974, Ancient Monuments and Archaeological and Remains Act of 1958, and the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation, and Resettlement Act of 2013. If the Lordship is clear with this, can I proceed with the statement of facts?
No, you the writ petition before the Allahabad High Court was filed under which article?
226.
All right.
Okay. Can I proceed?
Yeah.
Much obliged, my lordship. Statement of facts. So, my lordship, the Banke Bihari Ji temple in Vrindavan, Uttar Pradesh is a sacred Krishna temple of national importance, attracting over 50 lakhs of pilgrims annually. It is located in the organically developed heritage precinct with narrow traditional lanes and century-old establishments, which itself is the very essence of the existence of Vrindavan. And on 19th August 2022, a tragic stampede during Janmashtami celebration resulted in 2 deaths and 25 injuries during the morning Mangala Aarti, in which it's one of the most crowded festival events. And following this tragic stampede, the petitioner under public interest litigation has filed under Article 226 to the Allahabad High Court on 28th March 2023, and under which the state it directed the state to execute the Banke Bihari Temple Corridor project involving demolition of 300 structures and acquisition of more than 8 acres, and the project threatens the displacement of over 200 families, 500 small businesses, and the Yamuna River, that is 300 to 500 meters away, faces ecological risk because it's very vulnerable to all these infrastructural changes. The project violates the Ancient Monuments Act, as I've mentioned in the statement of jurisdiction, and also the Land Acquisition Act of 2013, denying fair compensation and proper procedures to affected property holders and stakeholders. By lordships, no meaningful public consultation was conducted with residents, shopkeepers, religious bodies, or environmental experts who are directly going to get affected if this project proceeds. And it is the process itself is arbitrary under Article 14. And despite spending 300 plus crores, the state failed to obtain mandatory environmental clearances and heritage approvals before commencing land acquisition. In April 2024, the petitioner filed a modification application to halt acquisition under the process, which was followed. The Honorable Supreme Court referred the matter to this bench. Therefore, we approach this bench. If my lordship is clear with the statement of issue, shall I move on to the arguments?
Please, ma'am.
Yes, much obliged, my lordship. My lordship, the first issue is whether the High Court mandamus under Article 226 directing a particular corridor scheme amounts to impermissible micromanagement of executive policy is a constitutionally valid exercise to remedy systematic failure and endangering life and safety. My lordship, we would like to submit that the separation of power is not merely an administrative convenience. It is a basic feature of our constitution and as established through a lot of landmark judgment, especially Keshavananda Bharati case, as we all are aware of it. In SP Gupta versus Union of India, 1981, the Honorable Supreme Court stated that judicial restraint is as much of a necessity as judicial activism, and it is only by a judicial blend of both that a proper balance can be maintained between the executive, legislative, and the judiciary. The overreach in question herein, my lordship, is that the Allahabad High Court Court's directive to implement a specific corridor plan represents a dangerous transgression into executive territory. By maintaining a particular infrastructure solution, the court has therefore violated constitutional boundaries, bypassed due processes, and ignored executive expertise. And my lordship, this was further held in Balco Employees Union versus Union of India, that the policy choices lies within the executive domain only unless they are arbitrary or malefic. The established precedents from several landmark cases has also been highlighted. For instance, in Narmada Bachao Andolan versus Union of India, the Honorable Supreme Court unambiguously held that development projects fall within the executive domain unless there is evidence of malefic intent. The court's role is supervisory and not substantial. Subsequently, in the case of the Supreme Court's Advocate on Record Association versus Union of India, further reinforced that courts cannot exercise executive functions without constitutional authority or institutional competence. Furthermore, my lordships, this principle was elaborated in Government of Andhra Pradesh versus P. Lakshmi, which basically emphasized that judicial intervention is warranted only only when there are unlawful or unconstitutional actions by the executive, not when courts disagree with policy choices. The remedy for concerns about crowd management and safety lies not in judicial micromanagement, but in directing compliances, ensuring due processes, and maintaining constitutional boundaries. And this was further established in the case that we have referred to, that is Ram Jawayapur Kapoor versus State of Punjab in 1955, in which the Honorable Court stated that it must ensure legality and constitutionality without substituting their opinion on the advisability of specific projects. So, my lordship, to conclude the first issue, I'd like to highlight that the doctrine of separation of power is not merely a technicality; it is a guardian of our constitutional democracy. When courts overstep their boundaries, however well-intentioned it may have been, they undermine the very system they are sworn to protect. The Allahabad High Court's specific corridor mandate represents precisely the kind of judicial adventurism that our Supreme Court has consistently cautioned against over the landmark cases I have mentioned. It also substitutes a judicial opinion for executive expertise, bypasses the constitutional process, and sets a dangerous precedent for future governance. The strength of our democracy lies not in the dominance of any single branch, but in their harmonious cooperation within their respective constitutional spheres. Therefore, that concludes my first issue. Should I move on to the second issue?
No, tell me, in case if
Okay.
the corridor gets made, what prejudice is going to cost you or the petitioners, in fact?
Pardon, can you please repeat?
I'm saying in case if the Allahabad High Court judgment is upheld and the corridor has been made,
Yeah.
what prejudice it is going to cost to the petitioners over there?
How it's going to affect the
What are the shortcomings and what prejudice why are the petitions so aggrieved in case if the corridor gets made?
Yes. Yeah, much obliged for your questions, my lordship. So the violation, this will be further dealt in the following issues, but I'll quickly summarize. So if this project does proceed to happen, my lordship, it's going to infringe the right, the freedom of their religion that is mentioned under Article 25 and 26, which
How?
yes, which basically states that within the facts of the case itself, we can see that all this pilgrimage roads and everything is being organically developed over the years, and it's become an integral part of the religious practices. It's the pilgrimage road itself, and if this project does happen, it's going to lead to demolition, and it's going to lead to forced eviction of 200 plus families. It's going to also further lead to 500 structures being remodeled. My lordships, we would like to also mention that this could have been taken care of by less restrictive measures, with less
Like what
restrictive.
all? In case if you have given the option, what all less measures do you think could have been adopted by the state?
That will be dealt in issue number 3. Should I?
All right, just I'll ask you one more thing. Probably
Okay.
just because of the fact that 200 families will be
Force
shifted to some other place,
Hmm.
I am sure the respondents are taking care of it by putting that particular settlement and so much offers to
No,
it.
my lordship. No, my lordship. Based on the based on the Moot proposition, it's clearly highlighted that the fair compensation has not been complied as mandated under article, not
So, but
article.
can you claim fair compensation under this particular petition under 136 or not? That's a
Yes.
separate legal cause of action.
Sorry to interrupt, sir. There is 1 minute left for the
No,
petitioner.
time could be extended. It's fine.
Okay. Yes, my lordship. We have approached under Article 136 because of
Because of the orders of the Allahabad High Court,
Allahabad High
what
Court,
I'm
but
trying to say is that in case if we want fair compensation plea could be raised in this particular matter itself, or you have a separate cause of action to approach the Allahabad High Court again and follow the law.
no.
All right, proceed with the second issue now.
Much obliged, my lordship. The second issue, whether reconfiguration of temple approaches, alleys, and religious circulation routes implicates Article 25, that is freedom to practice, and Article 26, that is management of religious affairs, and if so, the correct test to distinguish faithful facilitation from unconstitutional interference. My Lordship, this project proposes demolishing over 300 structures, as I have mentioned already, including century-old religious institutions, which is deeply woven into Vrindavan's spiritual fabric. These aren't mere buildings, they are integral to religious practice itself, like I have stated. So subsequently, in the case of, I've taken a reference of this case, in Commissioner Hindu Religious Endowments versus Sri Lakshmindra Tirtha Swami, the Honorable Supreme Court established that religious practices integral to religions are protected under Article 25. My Lordship, herein, this very structure of Vrindavan is protected under Article 25 because it comes under the religion itself. And subsequently, in the case of Adi Saiva versus State of Tamil Nadu, the Honorable Court also upheld that the exercise to freedom to practice religion through outward action is as important as the freedom of believing. The traditional pilgrimage routes and sacred valleys of Vrindavan are precisely such outward manifestation of faith, living religious practices that devotees consider essential to their spiritual worship. Furthermore, my Lordship, the Uttar Pradesh Sri Banke Bihari Ji Temple Trust Ordinance, which came into existence in 2025, explicitly mandates preservation of customs and traditions carried out since the time of Swami Haridas. In Section 4, subsection 1, it stated that requires ensuring continuity of puja, acharna, and paditi without interference. And also in Section 7, subsection 1 and clause A, it also stated that empowers the board to act in the best interest of the temple and its devotees. Yet this very project destroys what it sought to achieve, and to add more to it, in the case of Seshamal versus State of Tamil Nadu, it also stated that any state regulation altering essential features of religious practice violates Article 25. Article 26 guarantees religious communities the right to manage their affairs. This project demolishes that autonomy. In the case of Shiramut case, it established that religious denominations have fundamental autonomy over temple management, including rituals and administrative affairs. My Lordships, the traditional circumambulation routes that organically developed over centuries are fundamental to the divine experience in Pushtimar tradition, which has been highlighted in the proposition also. My Lordships, the fundamental question that arises is, we face a simple question, that is, can the state, in the name of development, obliterate the sacred geography that defines a religious tradition which has been spanning over the centuries? Because subsequently in the case of Ishwar Chandra Sharma versus Devinder Sharma Kumar, it established that religious denominations have constitutional right to manage affairs through persons who comprehend their specific traditions. The wholesale remodeling risk erases heritage and spiritual fabric that cannot be reconstructed once it's been destroyed. So, my Lordship, to conclude, the corridor project violates both Article 25 and Article 26 by destroying integral religious practices and pilgrimage routes, usurping temple management autonomy, which was granted by the 2025 ordinance, and also proceeding without meaningful community consultation of the direct stakeholders involved, and imposing an alien template on a distinct religious tradition. Honorable Lordship, religious freedom is not a privilege to be balanced against developmental convenience. It is a fundamental right, as I've mentioned through the landmark cases that I have cited. And also, the sacred cannot be demolished and reconstructed like a secular infrastructure. The devotees of Banke Bihari deserve nothing less than their constitutional birthright, the freedom to practice their faith in the sacred spaces their ancestors sanctified through centuries of devotion.
No, I'll ask you just one last thing before you conclude or before the other team members start.
Yes, my Lordship.
You have mentioned so many case laws,
yes,
particularly to the fact that it is a fundamental right to practice religion and so forth. Give me one case law in which the development of any particular area was curtailed down or was stayed down by the Honorable Supreme Court. For example, you have Kashi Vishwanath corridor. That was also developed. Various families were reallocated to some other place. Compensations were awarded down. And that was just for the betterment of that area. Give me one instance, because you mentioned the case law does not even include any of the case law, concluding to the fact that having the development plans for any of the temple to be reconstructed or that corridor to be reconstructed can be stayed down.
My lordship, if I may, your question is whether the state has the right
No,
in.
I'm asking you a simple thing. Give me any case laws till today in which any of certain sort of these development projects qua the temples have been stayed down by the Supreme Court.
The one that's been strike down, the
Yes,
religious
strike
right,
down or stayed down
by the court or the
by the
state.
Honorable Supreme Court.
Okay. My lordship, if I may, I think it's in the case of. Give me a second. My
Or you can
lordship.
answer me in the rebuttal rounds. You can just look into it till then. The
Yes.
other team member can start.
Thank you, my lord.
Please.
With the permission of the apologies. With the permission of the honourable bench, the co-counsel would like to address the collective bench as my
Please.
lordship and proceed with the remaining issues, including the prayer.
Yeah, please.
Much obliged, Your Honour. Your lordship. Right to livelihood and environment. May it please the court. The right to live with human dignity is an integral part of the Article 21 as reiterated in Bandhua Mukti Morcha vs. Union of India under Para 14. This honourable court has consistently linked the right to life and livelihood, making it imperative that the state's actions do not trample these rights under the guise of development or public safety. In Narmada Bachao Andolan versus Union of India, the court emphasized that the environmental protection is essential to safeguard livelihood. Therefore, the petitioners invoke this right to livelihood and environmental protection as foundational, which the state proposed corridor project dangerously undermines. The project would infringe on the livelihood of 500 small businesses and the right to shelter of 200 families facing eviction. This right to religious and cultural identity is also imperiled, giving the deep connection of the community with the Banki Bihari temple precincts. In Olga Tellis versus Bombay Municipal Corporation 1985, the court held that the right to livelihood is an essential component of Article 21, and eviction without adequate safeguards violates this right. This stance was affirmed in Devika Biswas versus Union of India, where the courts underscored the state's duty to protect livelihoods and threaten displacement. The landmark ruling of Chameli Singh and others versus the state of Uttar Pradesh recognized the right to shelter as intrinsic to the right to life and livelihood and required the state to ensure reasonable rehabilitation alongside eviction orders. The court stressed humane treatment and proportionality when displacement is caused by development initiatives. Then, the project threatens the fragile Yamuna ecosystem and heritage. Environmental rights include the right to preserve and protect ecological systems essential for human and cultural continuity. The Supreme Court in Lafarge Umaim Mining Limited versus Union of India held the doctrine of sustainable development, mandating the development that meets present needs without compromising future generations, Your Lordship. The Yamuna River, flowing within 300 to 500 meters of the project site, is ecologically vulnerable and culturally sacred. The absence of an environmental impact assessment violates both the Environment Protection Act of 1986 and the Water Prevention and Control of Pollution Act 1974. The Yamuna River Apologies, Your Lordship. The Yamuna River holds more than environmental significance. It is a spiritual lifeline sustaining the Braj's pilgrimage tradition. Lafarge Ume Mining Limited laid down EIA. Your Lordship, may I take a second? My computer is. May I continue, Your Lordship? The Yamuna River holds more than environmental significance. It is a spiritual lifeline sustaining Braj's pilgrimage tradition. Lafarge Mining Limited laid down EIA requirements to evaluate environmental consequences comprehensively. The Uttar Pradesh Braj Planning and Development Board Act 2015 explicitly calls for environment protection and forest safeguarding for present and future generations, reinforcing the public interest and in ecological welfare. The Supreme Court in TN Godavaram Tirmalpad versus Union of India reaffirmed balancing development with the environmental preservation. Recent news from Vrindavan today, that is on 8 September 2025, highlighted the Yamuna's vulnerability, emphasizing the responsibility of Mathura Vrindavan Development Authority Municipal Corporation to prevent construction or encroachments harming the floodplain. Construction in floodplain regions is prohibited, as mentioned in the case of Manoj Mishra versus Union of India, Your Lordship, from the NGT, reinforcing that such ecosystems shall not be compromised. Allowing this project to proceed risks eroding the spiritual, cultural, and natural character of the Braj's sacred pilgrimage traditions. The Supreme Court and the National Green Tribunal both have held the Yamuna floodplain must remain unpreserved. In Fellow Citizens Welfare Forum versus Union of India, the court required the state to justify why alternatives are inadequate before the environmental sacrifice. Lack of EIA and consultation was deemed unconstitutional. Green Earth Foundation versus Union of India recognized the environmental rights as inherent in the right to life, specifically protecting rivers as ecosystems, living ecosystems critical to health, spirituality, and culture. This project is threatening the Yamuna's ecosystem and violating these constitutional and statutory provisions for the same. The next part, Your Honor, Your Lordship, Nadivan Forest and environmental clearance. Nadivan Forest is located 1 kilometer from the Banke Bihari Temple, Your Lordship, and it is a sacred forest with immense religious, cultural, and historical significance tied to Lord Krishna's divine pastimes. The forest supports rich biodiversity and preserves the sanctity of the temple atmosphere. Recent tragic stampede incidents, such as the Avnishwar Mahadev Temple, demonstrate the dangers of disturbing such fragile ecosystems. The Supreme Court recognized sacred groves like Nadivan forests, such as Orans, forest lands protected under the Forest Conservation Act of 1980. In Samanta was the state of Andhra Pradesh, the court underscored prevailing alienation and disturbance of these forest lands, vital and cultural to this ecological sustainability. The Ministry of Environment, Forest and Climate Change has mandated the formulation to formulate comprehensive policies for sacred groves and protection of and conduct of nationwide surveys for the same. Your Lordship, environmental clearance is a requisite under the Environment Protection Act of 1986 under Section 3, Clause 1, Section 3, Clause 2, Clause 5, the EIA notification of 2006, which is issued under the Section 3 and 5, large-scale construction, which states that large-scale construction and redevelopment projects require prior environmental impact assessment, emphasizing a balance between development and preservation. The Center for Science and Environment recommends a robust environmental process which the state's corridor project neglects. Prioritizing modernization over ecological cultural heritage without due diligence is unconstitutional, Your Lordship. And as per, we have made annexures for the same thing, but due to an inability to project this in this meeting, Your Lordship, may I state it verbally? So, the environmental clearance process in India starts with the site selection, a conduction of EIA, which was stopped from the inception of this project, application for NOC, and then the SBCB arranges for public hearing, and after that, a few more steps which are conducted for the clearance of this project. So, in this case, Your Lordship, this has been not done from the inception of this project, since the EIA wasn't conducted, hence deemed unconstitutional. Next, Your Lordship, we'd like to propose less restrictive alternatives. The state has entirely overlooked less restrictive alternatives and less injurious alternatives. The Honorable Supreme Court in Bijo Emmanuel versus State of Kerala, 1986, emphasized that restrictions on religious freedom must be narrowly tailored with the smallest restriction possible. One such alternative of the digital queue management system was successfully implemented at Tirumala Tirupati Devasthanam, minimizing overcrowding while respecting devotional laws, Your Lordship. And I have the same annexures for this. May I state it, Your Lordship? So,
Yes.
We have made a table that states the temples that have successfully implemented digital management system, which is the Tirumala Tirupati Devasthanam, the Kumbh Mela, the Shirdi Sai Baba Temple, Vaishno Devi Shrine, and the Shabrimala Temple. And since these temples have already created this system, it has minimized overcrowding while respecting all the devotional laws. And Annexure 3 states the temples without digital management system, which includes Jagannath Temple, the Kamakya Temple, and the Banke Bihari Temple, which is causing overcrowding, etc. Now, moving on, the Banke Bihari Temple also has this provision for booking digital darshans, etc. But in the website which they provide for the users, it's deemed that the registration of Sri Banke Bihari Temple is not required anymore and could be entered as a walk-in, as mentioned in the website. May I move on?
I'm sorry, can you come with the last line, please? The last sentence you read.
The last sentence I read, which states the register for darshan in their website. May I read it out as it is mentioned in the website, Your Lordship?
No, just whatever you just read.
Yeah. Please note that the registration of darshan for Sri Banke Bihari Temple is not required anymore, which is mentioned in their website, Your Lordship. Yes, Your Lordship. May I move on to the next one?
Yeah, please.
Yeah, no deprivation without authority of law. The deprivation of property and forced acquisition must strictly adhere to lawful property, lawful authority, public purpose, and just compensation as held in KT Plantation with the state of Karnataka versus the state of Karnataka at 2011. Acquisition without transparent procedure or compensation violates the constitutional protections of Article 300E. Indo Development Authority versus Shailendra mandates acquisitions must serve public purpose under valid law with just compensation, Your Lordship. The corridor project entails forced eviction and demolition over 300 properties, affecting 200 families with 500 small businesses without adequate compensation or rehabilitation, violating these mandates, Your Lordship. Muralidharan Nair versus State of Kerala held strict adherence to procedural fairness is non-negotiable for
Apologies to
deprivation.
interrupt. You have 1 minute left.
Your Lordship, may I seek for extra timing since I'm still in the first issue?
Please.
Yeah. As mentioned, there has been a negligible provision for meaningful rehabilitation or stakeholder participation. Hence, the attempted land acquisition and demolition stand in flagrant violation of lawful authority and constitutional protections, Your Lordship. If it pleases Your Lordship, may I move on to the second argument?
Just tell me one thing in case if you just mentioned that since the fair compensation and the rehabilitation process has not been completed and probably not given to you in that particular sort of an extent as to what you might be looking forward to.
Yes, Your
So
Lordship.
what if the respondent actually gives you a fair amount of compensation and they also offer you a rehabilitation as per your own needs as to whatever you want to satisfy yourself with? Will then the grievance of the petitioner be solved?
It's still violative, Your Lordship, as these people, residents who have been living there, the business who are living there, depend on the economy of the Vrindavan pilgrimage. Hence,
No,
this would.
probably in case if they give you the same exact position as to what you are for now, or maybe an upper edge of that, then what? Are you guys actually fighting only for the compensation or the rehabilitation, or are you actually fighting for the protection of the temple and the monuments also?
Well, definitely, Your Lordship, it's violative of all the religious rights as well, because this infringes the environment, as mentioned before.
An
Under the
environment, in case if they can actually, in case if you can have a nodal agency appointed, let's say NERI gets appointed, and they carry out the research along with the EIAs and so forth, then what?
well, Your Lordship, it's still violative of Article 14 because there was no public consultation that was taking place.
No, that is not required. They can always hold a meeting and eventually at the end of the studies and whatever the problems any of the citizens probably might have, they can look into consideration, solve it out.
Well, Your Lordship, as per our arguments, it is required for Article 14 to be entailed. There was a violation of Article 14 because of the lack of public consultation, which was mentioned, which is
So in
required.
case if you get the public consultation one, you get this proper fair compensation two, you get the good proper rehabilitation, you get the proper environmental clearances, then everything gets solved from your end.
Well, Your Lordship, may I take a second to answer this question?
Please.
Well, Your Lordship, it's still a violation of Article 25 and 26 as a religious right, is what we respond to the argument.
Read
Um,
Article 25 for a minute. What
yes.
does Article 25 say?
Well, Your Lordship, it guarantees the freedom of conscience and the right to freely profess, practice, and propagate religion for all persons subject to public order, health, morality, and other provisions of the Constitution.
So no one is stopping you from worshipping the God.
Well, Your Lordship, as we mentioned before, it still curtails the cultural and heritage rights, which still fall under the freedom to freely profess. And this, well, Your Lordship, as mentioned
All
prior.
right, continue with the next issue now.
All right, Your Lordship. Um, Okay, so fourth issue, procedural due process and lack of consultation. Article 14 encompasses both substantive and procedural due process. In Maneka Gandhi versus Union of India, the Honorable Court held unequivocally that the procedure prescribed by law must be fair, just, and reasonable. It cannot be arbitrary, fanciful, or oppressive under paragraph 56. The state's failure to consult core stakeholders, including residents, shopkeepers, and religious bodies, and environmental experts who will directly be affected by the corridor project due to violation of procedural due process. The lack of consultation renders the decision arbitrary and unconstitutional. Furthermore, the state has failed to consult shopkeepers ignored environmentally and heritage-informed opinions, and denied adequate notice and opportunity to be heard. These omissions amount to arbitrary state action. The court in Ishu Chandra Sharma versus Devendra Kumar Sharma pointed out that issuing substantive directions on significant matters in absentia is necessary stakeholders is procedurally unfair and against judicial best practices. Effective crowd control, safety protocols, and public order maintenance during peak pilgrimage periods are undoubtedly crucial and must be managed with the framework of responsible temple administration. The Honorable Court in Common Cause Registered Society versus Union of India emphasized that public participation and environmental public hearings are essential for procedural safeguards in projects impacting environmental and cultural heritage under Para 75. The absence of such discussions and hearings undercuts the legality of and the constitutional validity of the project under Article 14. In SR Bomai versus Union of India, the court underlined that the state action is arbitrary where it proceeds without adequate public hearing and notice, especially in matters affecting communities under Para 302. The corridor project is failure to provide notice or opportunity to be heard in those impacted. To those impacted provides the arbitrariness of this decision. The judgment in Hanuman Lakshman Roskar versus Union of India illustrates public hearings and not mere formalities. They ensure reasonableness and fairness in the environmental decision making must be substantive and not as per para 47. The procedural lapses and the lack of consultation in this project thus violate these constitutional requirements, especially given the risks of religious, cultural, and environmental values intertwined with Vrindavan. Next one, the reasonable classification and the rational nexus. The principle of reasonable classification is anchored in Chiranjit Lal Chowdhury versus Union of India, which held that the classification must be based on intelligible differentia, distinguishing groups and possess rational nexus to the law's objective under paras 24 and 26. Any state action that is reasonable or discriminatory lacks connection to its purpose and violates Article 14. For projects impacting public interest like the Banke Bihari corridor, decisions must be founded on fair procedures, including public consultation. The exclusion of residents, shopkeepers, and religious bodies and environmental experts from the meaningful consultation here lacks reasonable or intelligible basis, violating fairness and equality. In Ram Krishna Dalmia versus Justice Tendulkar, the court held that the state actions must be based on relevant rational considerations and must not be arbitrary according to Para 18, ignoring critical inputs relating to ecological balance, cultural heritage, and social fabric of Vrindavan, which breaches this, and social fabric of Vrindavan breaches this principle. The next point, 4.3, consultation, public consultation as a constitutional mandate. Article 14 forbids arbitrary, discriminatory, and unreasonable state actions. Ajay Hasya versus Khalid Mujib confirmed that even legislative actions are subject to reasonableness and not arbitrariness under Article 14, reinforcing public engagement and reasonable administrative requirement under Para 16. The state's wholesale exclusion of major stakeholders in the corridor project contravenes with this mandate. Further, in KC Panikkar versus Union of India, held that the denial of the right to be heard and absence of public consultation amounts to arbitrary exercise violating Article 14.
Apologies for interrupting. It's almost exceed your time limit. And sir,
How
how
much
many
time are you
times?
looking forward to? Sorry, ma'am. How much time are you looking forward to complete your arguments now?
So, Your Honor, we're done. We just have the prayer left.
Just put down the prayer now.
All
Okay,
right.
sir.
May it please the Honorable Court to have the failure, just concluding my argument. May it please the Honorable Court to hold the failure of meaningful and inclusive public consultation renders the corridor project's decision-making process arbitrary and unconstitutional. Thank you. Moving on to the prayer, Your Lordship.
Please.
In the light of the above submissions, the petitioner respectfully prays that the Honorable Court may be pleased to set aside the Allahabad High Court judgment dated 20th March 2023 directing the implementation of the corridor project, declare that the state's decision-making process violates Article 14, 21, 25, 26, and 300A of the Constitution, direct the state to conduct comprehensive public consultation with all stakeholders before proceeding with any development project, order mandatory environmental impact assessment and heritage impact evaluation, mandate exploration and implementation of less restrictive alternatives of for crowd management, ensure that any future project respects the organic spiritual character of Vrindavan while addressing legitimate safety concern, grant any other relief deemed fit and proper in the circumstances of this case. We rest our case, Your Lordship.
Are you actually asking for a stay also till the time the matter has been heard, the project should be stayed?
Well, yes, Your Lordship, we're asking for the stay since there are less restrictive processes that could be taking place.
All right.
I now requested the respondent to conclude your proceedings.
The council seeks permission to approach the bench.
Please, sir.
The council seeks permission to address the bench, Your Lordship.
Please.
If Your Lordship may allow, I would like to point two very significant points before this court. First of all, that it was expressly mentioned in the Moot proposition that the story is a fictional story with no relevance to the actual Banke Bihari temple. So the facts they're citing, so the facts that my humble petition opponents are citing that about the registration procedure related to the actual Banke Bihari temple or the cases they're citing in the memorial should not be withheld, Your Lordship. And secondly, Your Lordship, the petitioners has approached this court under two jurisdiction, mainly under Article 136 of the Constitution of India and under Article 32 of the Constitution of India. Your Lordship, Article 136 of the Constitution allows the Supreme Court to deal with questions relating to substantive questions of law, and the ambit of fundamental rights are governed under questions related to substantive question of law. So we, the respondents, humbly request this honorable court to quash the second petition, which is related to Article 32 of the Constitution. Otherwise, it shall lead to parallel proceedings, which is a bar according to the principle of res judicata under Section 10 of the Code of the Civil Procedure.
Right.
Okay. If Your Lordship have no further queries, I would like to quickly mention the statement of facts, which the petitioners have failed to mention. And also, after which, I, the first counsel, shall be dealing with issue number 1 and 2, and my co-counsel shall be dealing with issue number 2 and issue number 3 and issue number 4. Apologies, Your Lordship. May I proceed? First of all, if Your Lordship may refer to para 3 of the Moot proposition, it is clear the primary reasons for the tragic incident that happened on August 19, 2022 are clearly mentioned. The primary reasons include overcrowding, number 1, lack of regulated entry and exit points, number 2, insufficient personnel, and number 4, physical constraints posed by surrounding infrastructure. Secondly, Your Lordship, if you may refer to para 5 of the Moot proposition, it is clearly mentioned that the state proposed the Banke Bihari Temple Corridor project. They brought it before the court when a PIO was filed. The High Court merely directed the state to execute the order which they explicitly drafted, Your Lordship. If Your Lordship has no further queries, I'd like to move on to issue number 1.
No, before that, answer me the para 3 you read, and you pointed out 4 things
Your
that
Lordship.
these were the shortcomings, and that is how you want to take it over and you want to redevelop. Having those 4 reasons
Yes, Your
is a
Lordship.
state failure. It's not a failure of the petitions over there. What steps have you taken to comply
Yes, this
with
is
those particular? Yeah.
Yes, Your Lordship. This is the reason why the state came up with the Banke Bihari Temple Corridor project, Your Lordship, actually. And it was in
No, but
consonance
what
with the
were you
Kashi
doing
Vishwanath
before it?
Corridor, Your Lordship.
What was the state doing before it?
That is
Why just all
like a
of a sudden?
procedural compliance. Well, Your Lordship, that is like a procedural compliance before the state. It was a fault on part of that, which the state humbly apologizes. And as the situation arises, the state is now duty bound under Article 21 of the Constitution to act accordingly.
Okay, and continue now.
May I proceed to issue number 1, Your Lordship?
Yeah, please.
First of all, issue number 1, whether the High Court's direction under Article 226 amounts to impermissible micromanagement of executive policy. Your Lordship, the prime question here, micromanagement, does not occur in this case, ipso facto or ab initio, because, as stated earlier, the project was exclusively drafted by the state. And when PIL was filed before the High Court of Uttar Pradesh, and the state proposed it, the High Court merely directed them to execute the order. The prime question here shall be if the High Court is allowed to issue such a direction. For that, Your Lordship, I would like to draw the attention of this honorable court to the reading of Article 226, which clearly states that the High Court can issue writs for the enforcement of rights conferred under Part 3 of the Constitution of India and for any other purpose. Your Lordship, the words any other purpose is of crucial importance out here. Your Lordship, the Supreme Court under Article 32 is allowed to issue writs for the enforcement of fundamental rights, but the High Court is under Article 226 is allowed to issue writs not only for the violation of fundamental rights, but also for other purposes. And Article 226 clearly mandates it by its language, Your Lordship. This was also upheld in the case of L. Chandra Kumar versus Union of India. If Your Lordship may refer to para 3, page 11 of the memorial, where a 7-judge bench of the court held that uh, the High Court has the power to issue writs and orders to the authorities of the state. Further, Your Lordship, this Honorable Court, in the case of Bandhwa Mukti Morcha versus Union of India, if Your Lordship may refer to para 4, page 12 of the memorial, this Honorable Court, quote unquote, stated that the jurisdiction of the High Courts under Article 226 is much wider because the High Courts are required to exercise this jurisdiction not only for the enforcement of a fundamental right, but also for the enforcement of any legal right. Please note, Your Lordship, but also for the enforcement of any legal right. In this case, Your Lordship, the stampede that happened on 19th August, it is a tragic event. It is a violation of not only Article 21, but also an issue of public safety. And when the state, in such a situation, orders the state to carry out a constitutional obligation and also the directive principles of state policy, the order of the High Court did not create any new policy, Your Lordship. It just ordered the state to execute the plan which was drafted by the state itself for the public safety of its citizens. So, and the High Court is very well mandated under Article 226 of the Constitution to do that. Moving further, Your Lordship, Article 21 of the Constitution states that no person can be deprived of his right to life except according to procedure established by law. This article imposes a duty upon the state to secure the welfare of the people and safeguard the right to life of every person. Your Lordship, this was also held in the case of Paschim Banga Khet Mazdoor Samiti versus the state of West Bengal. If Your Lordship may refer to para 9, page 12 of the memorial, the court clearly held that it is the duty of the state to secure the welfare of the people and safeguard the right to life of every person. Your Lordship, by proposing the project, the state discharges a positive constitutional obligation, and the High Court decided only the pros and cons of the case of the project. They did not edit the project. And finding that the project secures the welfare of the people, they issued a writ directing the state to execute the project. Your Lordship, I would like to point out one important aspect here, that we're not contesting that it requires demolition of about 300 structures or it involves land acquisition. But Your Lordship, the state's action is justified because it was done for the welfare of the people. We have all studied the utilitarian principle of jurisprudence, which was proposed by Jeremy Bentham, that law should be such that it is for the greater good. Law should be such that it is for the benefit of the greater good and for the highest number of people. This principle, Your Lordship, is clearly mandated in the Constitution of India as well, Your Lordship. If Your Lordship, even the fundamental rights are subjected to public order, morality, health, and also Your Lordship, even Article 21 of the Constitution mandates that right to life is there, but it is subjected to procedure established by law. So when the utilitarian principle is mandated under the Constitution, the High Court under Article 226 can surely issue a writ for the purpose of welfare of the people. That is for any other purpose, which we have already seen the interpretation of Article 226(1). If Your Lordship has no further queries, I would like to move on to issue number 2.
Yes, you're audible.
Hello, Your Lordship.
You're audible. You're audible.
Okay. Issue number 2, whether the reconfiguration of the temple approaches, alleys, circulation routes infringes Article 25 and 26 of the Constitution of India. First of all, Your Lordship, right to religion under Article 25 is subjected to public order, morality, and health, as the text of Article 25 suggests. Under Article 25, by the reading itself, the state is allowed to regulate the secular activity which may be connected with religious practices. Your Lordship, from time to time, to various precedents, such as the Shirurumar judgment, or the Ismail Farooqui judgment, or the judgment of SP Mittal versus Union of India, the court has numerous times held this one simple principle, that the state can interfere in social aspects related to religion, but the state cannot interfere in the essential religious practices or individual religion. If Your Lordship may refer to para 39, page 17 of the memorial, this Honorable Court, in the case of Sri Jagannath Temple Puri Management Committee versus Chintamani, quote unquote, had stated that Although the state cannot interfere with freedom of a person to profess, practice, and propagate his religion, the state, however, can control the secular matters connected with religion. All the activities in or connected with a temple are not religious activities. The management of a temple or maintenance of discipline and order inside the temple can be controlled by the state. The management of the temple is a secular act, Your Lordship. Similarly, in the present case, Your Lordship, the corridor project alters the approaches, alleys, and circulation routes, Your Lordship. In the present case, the corridor project only alters the alleys, approaches, and the circulation routes, which are aspects of crowd management, which are like secular activities as such. They do not form a part of the essential religious practices. For example, seva, arti, darshan, or prasad distribution, etc. Your Lordship, the prime question here is to decide that to determine if Article 25 and 26 can be invoked in this case, it should be determined that if the approaches, alleys, or circulation parts form a part of the essential religious practices. For that reference, Your Lordship, I'd like to draw the attention of this honorable court to the judgment of Shirurma judgment, that is the HRA Commissioner of Madras versus Sri Lakshmindra judgment. If Your Lordship may refer to para 48, page 18 of the memorial, the judgment had laid down a twofold test to determine if a practice, act, or space can be regarded as a part of essential religious practices. Firstly, we need to check if doctrinal text or denominational practices treat the act as essential. And secondly, we need to check if the contested measure doesn't allow the performance of essential practice. In the present case, Your Lordship, the access routes and approaches are logistical and contingent features of how to reach the temple, of how to reach the place of worship. They are not doctrinal acts of worship as such. They do not form a part of the rituals or something like that. So the first test under ERP clearly fails. Further, Your Lordship, the petitioners must submit concrete evidence as to prove that circular routes, alleys, or approaches are a part of the essential religious practices. There is no doctrinal text to prove it, no denominational pronouncements. Neither the petitioners have submitted any affidavits from recognized functionaries such as priests or purohits of the temple, stating that as to why those routes are indispensable, and they form a part of the essential religious practices, Your Lordship. Further, Your Lordship, there exists proof that non-essentially actually exists in this case, as the state has not upon the actions such as darshan, arti, or prasad distribution. The state section does not touch upon these things, which is why the essential religious practices doctrine is not violated, Your Lordship. Your Lordship, to distinguish between faithful facilitation from unconstitutional interference, we, the petitioners, propose a four-step test. Firstly, we need to check if the ERP test is violated, that is the essential religious practice test is violated. Secondly, we need to check religious practice versus secular infrastructure. As we have already proved that if the ERP practices are, if the ERP test is upheld and the state sections, like what they're doing is they're altering the alleys and circulation routes, which are part of how to approach the temple.
Apologies for interrupting. You have 1 minute left.
Okay, may I proceed, Your Lordship? I'll just summarize, like I have some points to which. Okay. And thirdly, we need to check for proportionality. Proportionality test requires that there should be a legitimate aim, there should be a rational connection between measures and aim, and there should be necessity. This was mandated in the case of Modern Dental College versus the state of Madhya Pradesh, Your Lordship. Your Lordship, the aim is legitimate in this case since the stampede on August 19, 2022 led to 2 deaths and numerous injuries, a proximate risk to life. Further necessity arises, as we have clearly proved in para 3 of the Moot proposition. It is clearly listed that the incident occurred due to physical constraints passed by the surrounding infrastructure. Now, Your Lordship, the AMA-SR Act cannot be invoked in this case, as for the AMA-SR Act to be invoked, the monument should be declared as a monument of national importance, the procedure for which is mandated under Section 3 and Section 4 of the Act. This was also upheld in the case of AMCA Construction versus Archaeological Survey of India. If Your Lordship may refer to para 81, page 24 of the memorial. Here, no evidence have been placed by the petitioners before this court that the temple is a protected monument under the AMA-SR Act. So, by this, I would like to conclude my arguments, and after which my co-counsel should take over.
Please, the co-counsel can start.
So speaker 2 having some issues, connectivity issues.
Yeah, so can speaker number one continue on her behalf, or we should wait for speaker number two? I'm okay with whatever you say.
Okay, hello. Apologies, Your Lordship. Actually, speaker number two, she is not able to turn on her microphone. She's facing some technical issues.
No, that is not a problem. But the whole thing is whether you want to continue her part also, so you can.
Okay. Okay, Your
Am
Lordship.
I audible? Am I visible?
Yes, ma'am, you're audible and you're also visible.
Okay, my apologies. Good afternoon, Your Lordship. This is the second counsel to appear for the respondents and will be taking up issue number 3 and 4.
Please.
Moving first to issue number 3, whether the state's objectives of crowd management and public safety under Article 21 justify large-scale redesign despite the availability of alternatives. Your Lordship, the temple precinct is a very old building and it has grown organically over centuries. Its lanes are narrow, winding, and surrounded by dense residential and commercial establishments. So, because of this, they do not comply with the modern safety codes. And it may sound easy to suggest alternatives like staggered darshan or tech-enabled flow. On paper, they appear plausible, but in reality, they are not workable in the present case. The old infrastructure of the temple cannot handle sudden surges of pilgrims during Mangal Aarti, Janmashtami, Holi, and other festivals when lakhs of people gather. The 2022 stampede tragically showed that even a few minutes of congestion can prove fatal when devotees are pressed into such bottlenecked or congested corridors. The Allahabad High Court in March 2023 already recognized these very limitations while directing the state to initiate the corridor project. The court has observed, quote unquote, protecting the protection of human life and public safety are paramount, and heritage conservation must evolve with the needs of the present. The respondents therefore humbly submit that structural redesign is not an excessive or arbitrary measure, but a proportionate and necessary response to these infrastructural realities. This Honorable Court in Modern Dental College versus State of Madhya Pradesh in paragraph 53 of its judgment defined proportionality into four prongs. Number one, it is designated for a proper purpose. Number two, limitation measures are rationally connected to the fulfillment of that purpose. Number three, there are no alternative measures available with a lesser degree of limitation. And finally, number four, there needs to be a balancing between the importance of the purpose and the limitation of the constitutional right. Applying this here, the legitimate aim of the Banki Bihari Corridor project is clear: to prevent stampedes and safeguard human lives in the exercise of religious devotion. The measures taken, like demolition of unsafe bottlenecks, creation of corridors, and construction of holding areas, sanitation, medical facilities, these are all directly connected to this aim. They are not arbitrary and they directly address the structural causes of overcrowding that alternatives alone cannot solve, Your Lordship. And furthermore, rupees 300 crore worth of amount has already been expanded on this project. And this is not just a financial expenditure. It represents that the administration has planned and it represents expertise and also public trust is involved into this. Public funds comes from taxpayers and it is meant for urgent public purposes exactly like this. And abandoning this project would not only waste this money, but also disregard public accountability. And more importantly, every delay increases the risk to human life. In state of Himachal Pradesh versus Ganesh Wood, on page number 23 of the judgment, this honorable court has affirmed, quote unquote, it is equally evident that while deciding where the interests of justice and equity lie, the court will also take into account and balance public interest. It is therefore most humbly contended that this project is not an erasure of the cultural identity of Vrindavan or Banke Bihari temple. Instead, it is a preservation in a modern and sustainable form. The aim is clear here: to protect devotees and heritage alike by creating safer, cleaner, and more accessible spaces. The project is not destructive but consciously heritage compatible. In Rajesh Suri versus GDA, more popularly known as the Central Vista case, the court held that modern redevelopment of historically significant areas is constitutionally permissible so long as the public interest, cultural continuity, and environmental safeguards are maintained. In paragraph number 208, the court specifically noted, quote unquote, the vision of the master plan as specified in the plan succinctly notes that blending heritage with modern patterns of development is a key feature. And my lord, this is not unique to Vrindavan. Globally, sacred and historic sites have evolved infrastructurally to protect devotees and to prevent further tragedies. For example, Nepal's Pashupatinath Temple, France's Notre Dame Cathedral, and UK's St. Paul's Cathedral and Westminster Abbey. These, all of them have integrated modernization to ensure continuity for future generations. And these are all centuries old monuments. The Bange Bihari temple corridor follows this exact same approach, keeping traditions and rituals untouched while modernizing only the secular aspects of it. This embodies the principle held in NDJL versus Union of India on page 8 of the judgment. Quote unquote, right to environment is a fundamental right. On the other hand, the right to development is also one. Shall I proceed to issue number
Please.
4? Much obliged, Your Lordship. It is most humbly contended that while consultation may be required under certain statutes, it is not an absolute constitutional requirement because it is not a fundamental right. The constitutional threshold under Article 14 is manifest arbitrariness. Not every administrative choice or decision that is going to face objection. In CPIL versus Union of India, this court laid down the manifest arbitrariness test. A state action is unconstitutional if it is unreasonable, unfair, discriminatory, or not guided by public interest. Here, the Vanki Bihari corridor is guided by public interest, by the most paramount public interest of all, protecting human life and safety of lakhs of devotees. And to call such an action arbitrary would trivialize the state's own constitutional duty under Article 21 to safeguard life and security. Unless petitioners prove that the decision was capricious, malified, or guided by irrelevant factors, Article 14 cannot be invoked on mere allegations. This court in E.P. Royappa versus State of Tamil Nadu made this standard clear on the page 39 of its judgment. Quote unquote. Secondly, we must not overlook that the burden of establishing malafide is very heavy on the person who alleges it. The allegations of malafides are often more easily made than proved, and the very seriousness of such allegations demands proof of a high order of credibility. Moreover, while environmental and land acquisition laws do prescribe consultation, it is a requirement there. The legal framework itself also recognizes exceptions in the case of urgent public safety. My lord, please put your emphasis on this urgent public safety or administrative exigency. Section 9 and 40 of the Land Acquisition Act and Section 20A of the AMASR Act justify expedited action by the state after specifically the 2022 stampede because in such circumstances prolonged consultation cannot override the state's duty to protect lives of people. This honorable court in NDJL versus Union of India, while referring to the judgment of NC Mehta versus Union of India on page 9 of the judgment, observed that, quote unquote, the balance between environmental protection and development activities could only be maintained by strictly following the principle of sustainable development. This is a development strategy that caters to the needs of the present without negotiating the ability of upcoming generations to satisfy their needs. My lords, temple corridor projects have already been recognized as legitimate and constitutionally valid public interest measures. The Kashi Vishwanath corridor is one such example, and recognition by the highest constitutional authority itself negates the claim that the present project is arbitrary. And further, as much as consultation is not a constitutional requirement, on the other hand, there is indeed a constitutional duty on the state to protect the rights of millions of devotees whose lives are endangered by unsafe conditions. And while consultation can reach in decision making, it cannot outweigh the duty to safeguard human life. The maxim salus populis suprema lex, The welfare of the people is the supreme law applies in full force here. In Mrinalini Padhi versus Union of India, this court emphasized that mismanagement and unsafe conditions in temple amount to a violation of Article 14. So, the mismanage automatically itself amounts to a violation of Article 14, as they reflect arbitrary neglect of devotees' rights. So, like far from being arbitrary, this project is a proportionate and constitutionally valid response to the dangers highlighted by the 2022 tragedy. And moreover, Article 21 encompasses not just their survival, but conditions of dignity, safety, and cultural enrichment. It has been reaffirmed in NDJL versus Union of India. Right to environment is a fundamental right. On the other hand, right to development is also one. Here, the right to sustainable development cannot be singled out. Therefore, the concept of sustainable development is to be treated as an integral part of life under Article 21. End quote.
Speaker
My
number
lord,
two,
prolonged consultation.
apologies for interrupting. You have only 50 seconds left now.
Okay. Prolonged consultation would put at risk the safety and lives of millions of devotees. Their Article 21 rights must be prioritized. And for a population the stakeholders in this corridor, such consultation would cause procedural delays, which after the 2022 stampede cannot be afforded. And lastly, it is pertinent to note that this Honorable Court upheld in Central Vista Court case in paragraph 184, quote unquote, a fine balance has been struck between need for public participation and effective functioning of administration. Furthermore, in paragraph 188, quote unquote, no country with a sizable population like ours can give a promise of direct participation to every individual in the decision making process in administrative matters unless the law so prescribes. Therefore, the respondents contend that the state's actions are not arbitrary and, on the contrary, are mandated under its constitutional obligations. The respondents are not creating arbitrariness but removing arbitrariness from temple administration itself. With this, the respondents most humbly rest their case and would like to move to the prayer if your lordship has no
Please.
further queries.
No, I'll ask after the prayer. You just conclude with your prayer.
Okay. Wherefore, in the light of the issues raised, arguments advanced, reasoning given, and authorities cited, this Honorable Court may be pleased to dismiss the present petition filed under Article 136 of the Constitution against the respondent and any other relief that this Honorable Court may be pleased to grant in the interest of justice, equity, and good conscience, all of which is respectfully
Now, tell me
submitted.
two things. One, protecting lives, since you mentioned that the whole development project is the idea of protecting lives of the millions of people who probably would come to the temples to worship and so forth. So, is there any particular
Yes.
constitutional provision available to you or fundamental right given to the state in which protecting the lives of millions of citizens at the time risking the other displacement of the already existing already people over there to some other sort of place or wherever just to protect the lives of millions? Can
Uh,
you actually like take away the home of someone who's actually putting over there since so long just by giving them certain amount of money? One. Second, you mentioned about the project of the principle of sustainable development. What actions have the state been concluded to conclude in a manner of to comply with the law laid down in Bittu Saigal when you talk about sustainable development? You talk about the principles, pollution play principles, you talk about the precautionary pollution principles. What all actions have the state been doing to protect that?
okay. First of all, Your Lordship, for the duty of the state, it is given under the Directive Principles of State Policy, Article
No, it's the
25(2)
duty
and
of the state given
26(d),
to
which
demolish houses or displace already existing people or existing population on that area to some other area by giving them ransom settlement, or maybe I don't know how much settlement are you offering to them. Because one of the pleas being taken by the other side is
Your
actually that the
Lordship,
compensation given by the state to them is actually quite low.
Your Lordship, first of all, this is merely a claim by the petitioners. They have no evidence to substantiate their proposition. You can refer to the paragraph number 6 of the Moot proposition, where it is mentioned that it is merely claimed by the petitioners that they have not received fair compensation.
What is
But
the criteria to
respondents
decide whether
have
the
given fair
compensation is
compensation.
fair or
We
not as
claim
per
that,
the Acquisitions Act or the other acts, the resettlement and the other so forth acts?
yeah, the schedule to the Right to Fair Compensation Act provides elaborated procedure for determining if the compensation is fair or not.
But anything in the rejoinder?
Sir, now 5 minutes to both the parties
Uh,
for the rebuttal round.
Rejoinder, rebuttal arguments, any?
Start with the petitioner.
Yes, I have.
Just there's a echo of
My
voice
bad.
from your
Yeah,
end.
my bad, my bad. Okay. The question I have, first of all, I'd like to address my co-speaker from the respondents end, the speaker one, has mentioned Article 226. But Article 226, we do agree that the High Court has the authority to issue it. We've never mentioned that the High Court does not have any authority. What we're saying is Article 226 also empowers judicial review and not executive administration. The High Court could have directed safety compliance, environmental clearances, and proper consultation, but it mandates a specific corridor project which crosses the judicial review. Second doubt I'd like to clarify is my speaker one has also mentioned the Shirmut case. In our memorial, if you refer to the 22nd page, we have also stated that the Honorable Supreme Court in the case of Shirmut case reiterates that religious denominations have fundamental autonomy of the management of temples and other religious institutions, including their rituals and administrative affairs. And if you refer to the Moot proposition statement of facts, within the first paragraph itself, it stated that the temple is dedicated to Thakur Sri Banke Bihari Ji, who is a form of Lord Krishna. Doesn't that comply with the essential religious practices? Because essential religious practices talks about whether you can remove whether that religious practice itself is very integral or not. It is integral. It's been a part of it over centuries, so it is a part of it. Therefore, yeah, that was the answer I wanted to give. And also, the rebuttal questions we have was, give me a second. Yeah, the rebuttal question I have was, the state could have taken alternative measures which have been available, and on top of that, the state did not do any alternative remedies that were the state comply with any other alternative remedies that was available? And secondly, why was the environmental clearance not done? Why was the EIA not taken place?
Anything to the rebuttal arguments the respondent would like to address to the contention raised by ma'am? Yeah, you
am
are
I
audible,
audible?
ma'am.
Okay,
Yes,
so
you are.
we have not followed the entire procedure, like taking public consultation and other social impact assessment, because like we have already demonstrated in our arguments, it was a matter of urgency, and lives of lakhs of devotees were at stake. And state was supposed to take expedited action after the consequences of the 2022 stampede.
No, that is fine, but ma'am is saying that like respondent have failed in their duties to take the EIA notifications or the
Oh,
approvals and so forth.
my
So what
lordship,
do
can
you want
I
to
add
say on
on?
that?
My lordship, if I may, can I add on to one sentence?
Please.
Yeah. So prior to the August 19, 2022, the state has not done anything. If the state really do cares about it, then why was the state silent unless and until the tragic stampede happened? And also, just one thing, other alternatives in that sense, I meant like the stacker darshan and technology-based crowd management, which have been implemented in a lot of other temples. Why was that not implemented? Thank you.
Okay, so Your Lordship, that is no argument. That we do take accountability that we should have taken action before, but there is that's no argument that just because we did not take an action before the stampede, we should not take it after the stampede. The state does take
Why did you
accountability
want
of
to
that.
wait till the stampede happens?
Yes, we should not have waited until the stampede. We should have taken this step long ago. We acknowledge that, but now that it is the way it is, stampede, the tragic stampede has already happened. It should not stop us from actually taking that
Okay.
action now. And furthermore, in the case of this Panki Bihari temple, staggered darshan, for example, it can regulate inflow, but it fails to control sudden crowd surges outside the temple where lanes coverage and whatever temples they have cited that already have implemented such strategies. They have not cited how many devotees visit there every day. Where is the other criteria that have to be taken into account? How many devotees? What is the stars there? How, like in Banji Bihari temple, it is evident lakhs of devotees gather there every year, and like technological inventions
That
tools
is
like
that is your
e-ticketing or CCTV.
responsibility, not of the petitioners, to take care of them. Nevertheless,
Yeah,
it's
but
fine.
if they
It's
are
fine. Neha
citing
ma'am, we can conclude now.
okay.
Your Lordship, uh, permission to ask one more rebuttal to the
No, it's fine.
petitioners.
We are done with the rebuttals now. Neha ma'am, we can conclude it out because the rebuttals will anyway continue till long, so there is no point.
Thank you,
Apologies, Your
Your
Lordship, but
Lordship.
it's one integral, just one rebuttal question of that, if you don't mind.
Quick.
Yes, Your Lordship. May the petitioner explain, in light of the four-pronged proportionality test laid down in the modern dental college versus state of Madhya Pradesh, how does the state's claim that no less restrictive alternative measures exist when the smart digital queue management system?
No, it's fine. Let's conclude it out.
All right.
Thank you, Your Lordship. Your Lordship are requested to please provide their valuable feedback to the councils.
Uh, See, eventually one need to realize once you probably once you graduate, I don't know which year of law school you guys are currently in. So the moment you graduate and the moment you actually become lawyers, so one thing you actually need to take into consideration is whenever you go and argue the matters. I have just observed like out of all of you, two or three people out there have been very rigorously relying upon the judgments and so forth, but the understanding of the actual facts is not clear. Why this petition was filed? What is the order of the court? What do you want to take from the Supreme Court as to why you need to also explain why this particular judgment is wrong, agreed by which you are challenging that particular order. So I
Clear.
think that was missing. Relying upon judgments, probably you might even not remember the judgments for now as to whatever you have read because you were just looking at a screen and reading it out. It's a very easy thing to do. Ultimately, you need to actually have a very crisp knowledge of the laws. What is Article 300? What is Article 25? What is Article 14? What are the exceptions to Article 14? You probably might not be knowing it because you have anyway focused yourself to the limited respect as to what the law is or what the law for this particular preposition is. So try to understand it out. Don't try to memorize it. Try to understand. And the moment you try to understand, all the judgments will also start to make sense to you. And be humble, be very professional once you try to argue. And there are certain words like yeah and so forth is not going to work in the court premises. And even for example, I never wanted to comment on it, but in the court also, like once I am or maybe some other colleagues of mine are, actually arguing for the court, no one can actually drink a water without taking the leave of the court. Or one, second, they have to go out of the courtroom and to drink water. They cannot even they cannot even sip a glass of water in front of judges and when the matter is going on. So just all these little things you have to be very careful, and all the best for the future. Yeah? This particular moot is something just to make you ready for the actual actions. Keep on participating enough, and it's not something that one moot is something going to be tougher for all of you guys. So you have a long life ahead, and hope to see you in court some fine day. All the best.
Thank you,
Thank
sir.
you.
Thank you so much,
Thank you
sir.
so much for your
Thank you, sir.
valuable feedback, sir. I
Thank you.
request the participants to kindly leave the meeting room and would request to judge to please stay in the courtroom.